I'm Drew Stevenson, and this is a lecture for my Law and Economics seminar about transaction costs and contracts. So transaction cost economics is a subfield of economics that derives ultimately from Ronald Coase's writings. And in this video, I want to encourage my students to think through how transaction costs can impact contracts and contracts law. So having said that, let's dive in here and talk about this. So every aspect of contract and contract enforcement involves transaction costs, right? So there's a cost to bargaining and negotiation, a really easy one. There's a cost of time, right? There's a certain amount of emotional and mental energy it takes. For a lot of commercial contracts, each side is going to hire lawyers who are billing by the hour, let's say. So we can actually put a dollar amount on that, or you may have a procurement specialist or something like that who's engaged in negotiating deals for a large corporation, and that person, we could actually prorate their time, and so the time they spend bargaining or working on a certain negotiation is time they can't spend doing something else. Then once we have a contract in place, we have to monitor that contract to make sure it's being enforced. So if you have a commercial contract for somebody to construct a building or a factory for you, you may want to check from time to time to see how what progress is being made. If you hire someone to help you write a book, right, or something like that, to teach a class, you hire someone to teach a class at your law school, you might want to make sure that they actually are, in fact, teaching the class. And then if one party breaches the contract, like stops performing under the contract, and this could be something very simple, like you did what they asked and they're refusing to pay you, or it could be that you paid someone and now they took the money and ran. But that takes time, right, and effort and money to enforce a contract. And so all of these things are going to vary on the situation. Certain types of contracts are very costly and difficult and almost not worth it to enforce. Sometimes it's very easy to negotiate something, but very difficult to monitor the performance under a contract and so forth. And as you would imagine, if you have multiple parties to the same contract who have all contracted, let's say a 5-way contract to do a certain thing, it's possible, but the more parties there are to a contract, the more complexity we have and the higher the transaction costs in each of these steps: bargaining, monitoring, and enforcing. We often talk about Ronald Coase in Law and Economics for what's called the Coase theorem, but there's another Coase theory, which is his theory of the firm. Both of Coase's sort of big ideas are related to the idea of that transaction costs really matter, right? And so sometimes people criticize the Coase theorem, I think unfairly, because he offers this hypothetical: if there were no transaction costs, then what would happen? And of course, that never happens. But I actually think that was Coase's whole point, is that transaction costs really matter. And a lot of economists before his time and lawyers weren't really thinking about that. And when it came to the firm, the question here was, why do we have corporations that have lots of employees as opposed to just a whole bunch of independent contractors? So in theory, right, you could have a situation like Uber, right, or where you are basically you have a whole bunch of independent contractors that agree to participate in a ride-sharing service, so you don't have to hire drivers, right, as employees and so forth. And the question is, why doesn't every business operate on this sort of model of having zero or very few employees and basically hiring contract people to do each step of the production process in producing goods or delivering services? And now, Uber is a special example, but in general, Coase said that it's often cheaper to bring operations in-house instead of using outside vendors, because it reduces transaction costs. And I'm going to give a very simple example of, I want you to think about a law firm, right? And so the and let's say that the law firm needs to make lots of photocopies, and so, but copy machines are really expensive, right? And so forth. So basically, every time you have let's say you open your firm across the street from a copy center like a Kinko's, or something, so that every time you need to photocopy anything for a client, you could just go next door or go across the street to the Kinko's. Well, at some point, you can probably save money, and not just because of the middleman cost, but also just any type of negotiating. So if you have a huge print job, right? So you're going to have to print all these deposition transcripts or something, make photocopies of deposition transcripts for a bunch of other parties, and so it's going to be tens of thousands of pages. It happens. And so you're going to have to negotiate this. And so at some point, for certain operations, it's cheaper to just have a person on staff that does this. And I'll give another example that's very, very common in our marketplace today, which is website design. So a lot of companies, especially smaller businesses or even law schools, or let's say colleges, they want to have a website, and so they hire a company basically to design their website and set it all up and make it look nice and make sure it functions and give them search engine optimization and things like that. Because rather than have let's say the entrepreneur of the business figure out for himself how to set up websites, right? And but at some point, if you have a business that depends a lot on your website and you're constantly updating and revising your website, it might be worthwhile for you at your company to have a website person, right? A specialist, a designer, or somebody who does the maintenance of your website. And so there's some critical point at which it becomes easier if that person is there, right? You could just stop by their office or stop by their desk and tell them, talk about what they're working on with their website and things you want done a little differently. And if you are always using somebody outside, not in-house, there's a lot more steps involved with setting up meetings or setting up phone calls to talk about things and looking at mock-ups of web pages and so on. And so for some companies, if you're going to be making a lot of changes regularly to your website, it's easier to have that person just kind of down the hall, right? Where you can pop into each other's office and talk about what's going on and double check about things and so forth. So it reduces the transaction costs. And in the aggregate, for a large organization or a large enterprise, this can really add up and result in a significant savings. There are, of course, downsides, right? There are reasons it's much more, employees are more expensive because of providing the laws that require providing benefits and things like that than outside contractors. So there are definitely some downsides to this, and this is part of why you have companies like Uber that basically just function as a kind of coordination service between people who need rides and people willing to provide them through their app instead of hiring drivers. It could go both ways, but you should be aware the transaction costs are one of the explanations for why we have the employment relationship in terms of in-house employees. The standardized contract verbiage between parties can help streamline both negotiations and contracts. So if everybody knows what an arbitration clause is or a venue selection clause, and we kind of have a stock phrases that we use for, let's say, binding arbitration, any disputes under this contract will be resolved by binding arbitration, right? So I just said it, right? And if everybody knows that, then there's no surprises, right? So it's not going to shock the other party when I bring that up in negotiations. Hey, let's have a binding arbitration clause. They know exactly what I'm talking about. And we both kind of know what to expect and know what the courts do with those and so forth, what that means. And so if the more we have standardized contract verbiage, it basically saves a lot of time of explaining things during negotiations or reducing the risk of surprise or unpredictable outcomes with enforcement. But of course, you can take that too far and have it evolve into an adhesion contract, right? Where you have a standard form contract and basically you just say, here, you're stuck with all of these terms and we're not negotiating anything. And of course, standardized contract verbiage saves a lot of time, but it also tends towards what we call the boilerplate problem, that after a while, people aren't really deliberating. So deliberation and intent fades because we're just reusing the same words and phrases that people aren't even thinking about. They're just copying and pasting from previous contracts. And so this is probably something you talked about in your contracts class. What do we do with contract boilerplate? where we have this sort of standardized verbiage, and we're not sure that the parties really had any type of intent or thought about those particular words. The contract lawyers just included it because we always include it. Now, clear rules of contracts like case precedent or statutory provisions, for example, a statute of limitations for bringing a lawsuit to enforce a contract. All the clearer the rules are, the more it reduce both cost of negotiation and enforcement thereafter. Think about things like why are so many corporations incorporated in Delaware? Well, part of it is because there's they're business-friendly rules, but the rules are also clear, right? And not only are the statutes clear, but there's so many corporations are in Delaware, are incorporated and litigate in Delaware, that there's a huge body of case law. When I was practicing law, I was in a little state in New England where it was pretty common that you would encounter a legal problem as a practitioner in this state, where it was a case of first impression in our state. We would have to borrow or ask the court to apply law from neighboring states or the American Law Institute's restatement or something like that. But Delaware is unlikely to have that problem because they just have so many corporations are incorporated there. They've had so many opportunities to consider things from every possible angle. So people really like this predictability. And, and so therefore, if parties can just say, we're following Delaware law, the lawyers on both sides know what that means. That has a lot of implications, and it saves a lot of time in negotiations. And then when we go to enforce things, we kind of already know it's a streamlined process because we know what's going to happen. The same can happen with familiar trade partners or familiar transactions. Those are going to have lower transaction costs or bargaining costs, right? So if you have a client that you've done legal work for many times over the last 20 years, then they're not going to have as many questions when they come in for a consultation about how the fees work, right? Or how long things take, because you've dealt with each other for a long time, right? If you are renting commercial space and you've had the same landlord for 10 years, hopefully it's a lot easier to work something out, to ask for a repair, or for the landlord to say, I need to get into the apartment because of we have a building inspector coming through, or something like that. And so the more experience the two parties have with each other, the lower their bargaining costs will be. Now, keep in mind under the Coase theorem that, so now I'm not talking about the theory of the firm, I'm talking about his more famous theorem. If transaction costs are low, like you have few parties, or what makes transaction costs low? You have only two parties and they're familiar with each other. They live next door to each other. We have a simple, straightforward transaction. People will often contract around whatever the law's ex ante assignment of rights or duties may be. Now, I have other videos that I assign to my students about the Coase theorem, some from me and some from other professors. But just as a quick recap in the contracts context, Coase had this hypothetical of farmers and railroads, and we could also put it in terms of, let's say, a farmer versus a rancher, right? And so let's say you have somebody who's growing crops, and then the guy next door has herds of cattle, and the herds of cattle keep coming in and eating the crops and trampling the crops. So the question then arises, whose duty is it between the two adjacent property owners to put up a fence to keep cattle from trampling or eating the farmer's crops, the farmer or the rancher? And the law could assign the right or duty to either one, but Coase would then ask the question of which is more valuable, right? So let's say the herd is worth millions of dollars and the crop is not worth very much, right? So we're just growing straw or something that has a low market value. And but the law assigns it's the farmer's decision about whether to put up the fence, and the farmer doesn't want to because at some point it's a low value to him. Well, at some point the rancher or the farmer wants to put up a fence, and the rancher says, no, I actually need more grazing land. So the rancher might just buy out the farmer, or vice versa. If the farmer's growing a very, very valuable crop, like ginseng or something like that, and the rancher's herds are kind of worthless at that point, let's say, the farmer may buy out the neighboring ranch so that they don't even have to negotiate. It doesn't really matter what the law is. So the question Coase asked in his article, The Problem of Social Costs, is it worth it to one of the parties to buy out the other party in the situation? And how realistic is that? If this is something that there are adjacent farmers and adjacent landowners, and it's very likely, it's very clear that one side has a lot more to gain and lose than the other party, and so they're going to buy out the other party, Coase would say, then that's going to happen no matter what the law was to start with. So if the crop is more valuable, the farmer will eventually pay off the rancher. If the herd is more valuable, the rancher will buy out the farmer. And if the law already privileged the more valuable usage, that party would not have to pay off the other. Okay, so let's talk just a moment about this. Coase said that if transaction costs are zero, the law will not change the final outcome, in the sense that the party with the most to gain will eventually pay off the other party who holds the legal rights in the disputed matter. And as sort of a corollary of this is that transaction costs are what really give the law its verve, right? And so why does the law matter? Because the parties can't just transact around it. So so you could have a situation where the law forbids certain transactions. You're not allowed to sell yourself into slavery, for example, or sell your children, or things like that. And so in that sense, because the law has made the transaction cost very high, the law really matters, right? You can't bargain around that type of law. On the other hand, let's say you have a situation with parties where it's very complex, right? You have corporations in different countries who speak different languages and so forth. And to the extent that negotiations are difficult, the what the legal rules are going to say is going to have a lot more impact on what transactions result from this. Or to put it another way, transaction costs are never zero, and sometimes they're so high that private resolutions are impossible. And I'll give you another example: air pollution. And so let's say that there's a power plant in Ohio that's putting a lot of sulfur dioxide into the air, but that's not going to just stay in Ohio. That's going to disperse and come down as acid rain in Vermont and Maine and New Brunswick and Canada and so forth. And so now maybe the people who live in Vermont could all get together and pay the Ohio power plant to stop putting out so much pollution, but it's really hard to get all of that many parties together, right? So the transaction costs are just inconceivable. So if you have pollution that affects many people across large areas, then we really have a problem. We're not going to have a transaction result from this. I live in the place I live in, Texas. There was a period where they were doing a lot of development in my area. So they were kind of clear cutting forests and putting in new housing developments. And then they would have these massive fires where they burned all the trees that they cut down. And I would get up in the morning and go out to my car, and it would be covered with everyone's car in the neighborhood. Everything was covered with a very fine layer of ash, almost like frost, right? Well, that's a nuisance, right? I have to go get my car washed now or something. Or you get the ash on your clothes when you're getting in and out of the car. And of course, maybe if everybody who's having this problem could all get together, we could go and find the person who's burning stuff and pay them to stop. But really, it's a minor inconvenience. It's not worth it to me for all the hassle of like organizing my community into this result. So I just deal with it. I just go and get my car washed or wait for it to rain or something like that, because the transaction costs are too high. And that concludes my kind of quick overview lecture about some of the ways in which transaction costs affect contracts.